Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a valuation mediator and expert in St. Louis, Missouri. I'm talking today with Gary Martoccio. He is an employment attorney on the plaintiff side, and he's licensed in 9 states based in Tampa, Florida. And today we're actually discussing employment law for business owners and really primarily talking about prevention. And so welcome, Gary. How are you today?
Hi, Melissa, thanks so much for having me. I appreciate it.
Now, this is an interesting topic because you actually work mostly for employees. And so you're giving our business owners kind of a perspective of maybe how to prevent some things, how to be mindful of some maybe changing landscape in the political arena as well. But I think that when we started off and just kind of getting to know this particular topic, because you are an attorney, and you were looking through the lens of employment law from not only the employee side but the employer side, but also potentially talking about mediation and how you can get some of these, maybe not making it be such a huge claim. Would that be an accurate assessment of what we're going to talk about today?
Right, absolutely. So, yeah, I entirely practice on the employee or plaintiff side, is where I devote my practice, but certainly can share some experiences and provide some guidance and give a little bit of perspective from this side for business owners, which is typically my opposition. So yeah, definitely mediation is a big part of my practice. We resolve a lot of matters in what's called the EEOC process, the Equal Employment Opportunity Commission. They offer a mediation program. It's a government agency that most employment-related claims have to go through before they can move forward into a lawsuit. So a ton of cases get resolved there. And even cases that go into a lawsuit, typically the court's going to order us to mediate. It's depending on what jurisdiction you're in, but the vast majority of federal and state courts will require mediation at some point before a trial. So mediation is a very popular place to settle a claim. A lot of different civil claims, but employment law specifically, a lot of cases can get resolved in the mediation process, and it's a great tool. I would say employment law, when we head into these mediations, typically the parties are valuing the cases very, very, very differently. You see some wildly different opinions on the way to value a case. But a lot of times we can come together, and if everybody shows up in good faith, there's a really good chance they'll get resolved in mediation.
Well, and we have a lot of, I guess, topics rolling around in media right now with DEI, with work from home, with forcing people to go back to work, with, leave, family leave and such. And I think in general, if we just look like when you're running a business or you're starting a business, you don't really think about hiring people. And then you start hiring people, you start growing, and in my mind, I see a lot of businesses just get in over their heads. They might know, these are questions that I can or can't ask in the interview, or these are things that I maybe can do with an employee. But a lot of times they just even get stuck at understanding basic terms like at will employment and what are my responsibilities as a business owner? What are the employees' responsibilities? So can we just start kind of at a base level of what you can tell us about what we need to know as business owners, having employees, or the responsibilities that we have towards those employees?
Right. No, that's a great question, and the term at will employment, I think, is both employees and employers alike don't understand what it means. A lot of employers think, oh, it's at will, I can do whatever I want. And I'll first say almost every state in the country is at will. I think 48 out of the 50 states are at will employment, meaning you can get let go for a good reason, bad reason, any reason. You don't need a reason. There's no guarantee of a certain tenure of employment. On the flip side, the employee, if you're an at-will employee, you can leave at any time with no notice. You know, People think they have to give like 2 weeks. No, that's not required as an at-will employee. So it's a reciprocal. You can come and go as you please, basically, but that doesn't mean the employees don't have rights. And there's exceptions to at-will employment and that's going to fall under discrimination and retaliation. There's statutes protecting against discrimination and retaliation. There's also what you mentioned briefly, medical leave. There's laws surrounding that. Pregnancy related protections. Employees also have both maternity and paternity leave. The Family Medical Leave Act is going to govern most of the medical and pregnancy related stuff, but there are also some other laws that touch on that as well. But just generally speaking, employees do have rights even in an at-will employment environment. And I think a lot of employers get that wrong and may make decisions without kind of thinking through that there's a potential for a legal claim from this employee. So yes, you definitely want to consult with counsel before making decisions, and on the employer side, and then employees, if you feel you're wronged. Well, that doesn't always mean that you have a claim. Being wronged isn't always illegal, but there is also a chance that the employee can have a claim, and I would encourage them to consult with counsel as well to make sure their rights weren't violated.
Well, and it's interesting because, and we didn't talk about this before we started, but it got me thinking just now, in as you're hiring people, a lot of times you're going to enter into maybe an employee contract or with that, because like in the accounting world, in the finance world, in the valuation world, we have these employee contracts, we have non-solicitation agreements, we have non-compete agreements. Are those even viable at this time? Or, should we be looking first towards that agreement and what it stipulates in how our arrangement, or does that not matter in an at-will state as well?
That's a great question. So you can still have an employment agreement and the employee still be at will. In fact, most of the time, when an employee gets their something laying out the terms and conditions of their employment, or maybe a non-solicitation, non-compete, something saying they can't share confidential information with others. Usually it will say that this does not change that you're an at-will employee. So typically you want to spell that out. And if an employer's agreement doesn't say that, it probably should, right? Now, not everybody is an at-will employee. I will say that members of a union typically aren't, because that would be governed by a collective bargaining agreement. And that usually has some like steps that have to be taken before termination and has some appeal rights, et cetera. So not every private employee is. And then there's also certain situations where just because you're in an at-will employment state doesn't mean you can't give someone an employment contract that has terms that says the employee can only be fired for cause. You're seeing that with, athletics, sports. They're either members of a union and or on guaranteed contracts. You're seeing that with coaches of sports as well. Doctors, a lot of times, will have contracts with their practice or a hospital that set out a duration. Here's the length of employment. Here's how much you're going to be making. It's for X amount of months or years, and you have to give X amount of notice. And if we terminate you, we have to give you X amount of notice, or we have to have cause to terminate you. So there are ways to agree otherwise outside of at-will employment. So an employer and an employee can agree that there is a guaranteed duration of employment, or there needs to be cause to terminate, or there needs to be a notice before you resign. But an employer typically doesn't have an incentive to, like, why would an employer do that? Unless the employee insisted on it, and unless the employee was in a position of high demand, that's why you're typically seeing with doctors, athletes, et cetera, where they can say, I need a guaranteed contract, right? Or else I'm not going to give you my services. So it's rare to see it in just your everyday work. Even lawyers, like myself, when I worked for a law firm, I was an at-will employee, and most lawyers are. So yeah, there would be no reason an employer would want to go outside of at-will, but that doesn't mean that they can't. I think the short answer to your question, they can contract with an employee otherwise.
Well, and it's interesting because I think that for the most part, there's been a lot, like again, people know the questions that they can or can't ask when they're hiring. They know, some of the ways that they need to operate, even with the work from home or going back to work kind of situation. I think that people are at least starting to become mindful of what is their responsibility, what is the employee's responsibility. But I think a lot of times where you're coming into play is that, there are things that happen that the business owner does wrong or improperly. And so, what are some of those common legal mistakes that a small business owner actually makes when they're firing employees? Because that's where this, either wrongful termination or, if it's based on discrimination or it's based on some other issue, what do you see small business owners just doing all the time and they have no clue that it is incorrect?
Right, right. I think goes back to what I said earlier. Just thinking at will employment means the employee absolutely has no rights and we can do whatever. And hey, we're in at will employment state. We don't have to have a reason. We don't have to give you a reason. I think that the biggest thing to do, if you have human resources, obviously have that human resource professional review the termination before making the decision to say what could this person possibly claim, or if you don't have HR, get some kind of outside counsel or an HR consultant, or you can go straight to outside counsel right away, right? So I think having someone that has knowledge of the law review a termination, I think would be one thing that I'd recommend to any small business owner, just to be sure. And you want to apply your policies equally across the board. I think that's a big thing. If you're first of all, you want to have policies in place as far as progressive discipline. And you want to apply them equally across employees of different races, genders, etc. So that's a big thing. You want to document. I think you want to have proper documentation before you would terminate an employee, to where you gave them warnings, write-ups, or if it was something super egregious, you want to have documentation of that. If you went straight to a termination without any prior warnings, you definitely want to have something to back up your decision should it be challenged at a later time by the employee saying, "Oh, you discriminated or retaliated against me." Obviously, if someone had made a complaint about discrimination, you want to treat that situation very carefully. If someone was having issues with accommodations, medical accommodations, or was on medical leave or had pregnancy leave coming up, you really want to be careful as an employer, because those are a lot of times I see cases where someone was about to take a leave or was on a leave or just returned from a leave, and that type of timing gives us a really good claim typically, if there's a termination in a close proximity, as well as a termination in a close proximity to an employee complaining about discrimination. So those are the type of things I look for as a plaintiff's attorney, because those are going to be undisputed facts. Of course, whether someone was doing a good job or a bad job, a lot of times that's subjective, but the timing is an undisputed fact. And when we have an undisputed fact in our favor as a plaintiff's attorney, that's something we feel good about. So if I was telling somebody on the defense side what to be mindful of, is look out. If the termination does have suspicious timing, you probably want to be a little more careful.
Well, and I think that, you talked a little bit about some of the things that they should document before terminating the employee and how they should have some processes in place. Is there really any way that a business can protect itself from these wrongful termination claims? Because, a lot of times when somebody leaves, they just may have, they just may feel that everything that went down was wrong, right? Or if they're a toxic employee, right? And they have been toxic with the whole team, you're removing somebody. And what if we don't have good reasons for doing it other than they're making a toxic environment, or they're, maybe they're a high performer, but they're just lacking in some of the personality skills? To me, that almost seems like that would be ripe for a litigation that they would bring towards you, because it would be like retaliation for firing them in some capacity. So can you protect yourself, or is there any things that you can do other than having an attorney on call kind of to talk through these
Right.
things?
Right. I think, like you said, you want to document things, especially the more subjective issues. If someone just is having a behavior issue, or if someone is performing poorly, but it's not like a sales job where you can look at the numbers, right? If it's just general poor performance. Now, if someone's absent or they're late, that's more objective, but you still want to document that. And you want to have a record keeping system, right, for tardies, for absences, et cetera. So I would recommend having that. If there is performance issues or behavior issues, an improvement plan is a big thing that you see employers do. Put that employee on an improvement plan and actually give them an opportunity to improve. A lot of times when I'm representing employees, I see performance improvement plans that they're kind of just a sham. They're just to try to check a box for the employer, and they set unreasonable goals, or just basically it's written in a way to where they're getting fired at the end of the duration of that performance improvement plan. But I would recommend an employer have like a legitimate performance improvement plan and try to help that employee. And then if it doesn't work, then I think the employee can only have themselves to blame, and or probably less likely to bring a claim. Another thing we see a lot is employers offering employees severance agreements upon termination. That severance agreement is typically going to contain a release of claims saying, in exchange for the amount of money you're offering me, I'm agreeing not to take legal action. That's something that can be done. There's a lot of different theories on it, and I'm probably not the best one to give insight on this because I'm on the plaintiff or employee side, but some defense attorneys, they think it's great. Always offer it, see what happens, see if someone signs it. And they usually offer some small amount of the attorneys in that camp. There's also some other attorneys that say, well, don't offer them anything, because if you offer them something, then they're going to think they have a claim. Then they're going to go to an attorney like myself and try to negotiate up. And then there's some folks that, on the defense side that will say, offer them a good amount so they sign it and don't go to an attorney. So I mean, there's a bunch of different theories on it, and you probably want to do what's best suited for your own business. I think it'll depend on how many employees you have, how many employees you're typically terminating, things of that nature, as to how you want to play it. But a severance agreement is a good way to try to avoid a claim before it starts.
Well, that is kind of interesting because I think we have, currently large government agencies that are letting go of a tremendous amount of employees.
Yeah.
And do you see, maybe we should flip around and look at it from, because a lot of people that listen to our podcast are also employees, and they are in these situations where, they're very concerned about the future. They're very concerned about whether they're going to be employed. And, what if I'm a valuation analyst that's been there for 20 years, and what should I be doing proactively to make sure that, I have a case in this situation? If I came to you and said, well, I think that I was just kind of let go and I don't really understand the basis for it, what are you looking for in that case to really have something to fight for?
Right. I think in a mass layoff type situation, it's a bit difficult to bring a claim, right? Because it's hard to find the discrimination or retaliation. I don't do much, if any, federal government employee work. I do. I'm mostly private employees, but I do work for employees in city, county, state level. Federal government has its own system for that. It's the EEO process instead of the EEOC typically that you have to go through. So that's not a space that I'm in very often. So I wouldn't say that this is what I'd recommend to federal government employees, because I'm not as familiar, with what they're going through. And honestly, since I don't handle much federal work, or I don't handle any federal work right now, I haven't even been keeping up as much with what's been going on in that space. But other than what everybody sees in the news. But I would say, in general, if you feel like the termination was wrong, you want to consult with an attorney. If you're asked to sign a severance agreement, you typically are going to have 21 days, if not more, to review it. And even if you don't, you still should consult with an attorney like myself, and they can let you know if they believe that there's something to move forward on. Now, what I'm looking for, like I touched on a little bit before, timing between a complaint made, timing between a medical leave, a pregnancy leave, and a termination, that's good stuff to move forward on. And then discrimination claims, looking to see if there was any discriminatory comments made based on race, age, gender, disability, sexual orientation, national origin, religion, etc. There's a number of categories. I'm looking to see if someone asks for medical accommodations in the workplace, like I need light duty or I need to work remotely. There's a lot of back and forth going with that right now. People being asked to come back to work, and if they have a medical reason to work remotely, then there's something called the ADA, the Americans with Disabilities Act, that would govern. And the ADA is very gray, and it's really case specific and fact intensive. It's a fact intensive analysis that's done by the court. But basically, if the accommodation is reasonable and does not pose an undue hardship on the business, and that employee can perform the duties of their job with the accommodation requested, typically courts are going to say that needs to be something that the employer grants. Remote work was really disfavored by the courts in the past, but as people have been proving to perform their jobs just fine remotely and technology has advanced, I think the courts are shifting a little bit toward, okay, employers may need to actually take a look if they can accommodate someone remotely. So we're seeing a lot of those type of cases. Most employers are cautious and they're on the side of caution and don't outright deny accommodations. But some employers have a little more risky approach, and I think it's really case by case and fact intensive. It's hard to say without looking at the specific facts of someone's situation. So that's why I'd say contact an attorney if you're having issues related to accommodations, and they can let you know if they think they could help. But again, the law is very gray on that. But yeah, that's about the gist of it. I think that's a good summation of the type of cases that I see and what we're looking for.
Well, and I think that, we've talked about some of the ways to prevent, like what you can proactively do as a business owner to avoid some of these employment lawsuits. In the employment contract, if you had an employment contract, could you put a mediation clause? Like, would that govern it? And then also, what size of companies do you normally see these happening in? Is it under $1 million of revenue? Are these small companies? Are these the mid-size? Are these big, more corporations that we're talking about?
Right. I see cases from everywhere, all across the board. I mean, from the small, well, basically, to meet the federal statutes, you have to have 15 or more employees typically for most claims. So there's some different states and some different type of claims that has a lower threshold, but for the most part, 15 employees is what you need to be covered by the federal statutes. So I see people from employers that have 15 employees all the way through, the biggest companies in the world. So, and everywhere in between. Typically the more sophisticated, advanced companies have massive legal or HR departments, and they're making less missteps. But again, even in the biggest companies, there's a lot of subjective decisions being made, like we just talked about. So that's leading to a lot of litigation. Typically, you won't see a large, sophisticated company make an error on something very basic, like not knowing they needed to grant someone FMLA leave when that person was eligible. You're seeing those mistakes mostly in smaller employers, maybe rapidly growing employers that aren't keeping they're growing faster than they're able to have a developed HR or legal department, right? So we're seeing it all across the board. Mediation and arbitration, that type of agreement can be put in someone's employment agreement, where there would have to be some kind of mediation required before the claim got submitted forward. We see that a lot. Now that's going to come at a cost to an employer, which if it goes through the EEOC's mediation program, there's not going to be an out-of-pocket cost to pay a mediator. But yes, you can definitely have some kind of agreement to try to mediate disputes before they happen. I think another big thing is just the way that you treat employees when they're terminated. I have a lot of people that may not have contacted me come to me just because of the way they were treated on the way out. Be sympathetic to the employee. I mean, I think treat them, like the humans that they are. And I think that may help someone from being emotional and look into, hey, do I have a claim or not, right? And then another thing, I get a lot of calls from folks that the employer contested their application for unemployment benefits. And I think, if I was advising an employer, I would say there's no point in contesting someone's application for unemployment benefits. The amount of money that it's going to save you in relation to what a claim can cost you, it's not even close. I don't know. Some states it may not even save you any money. It depends on the size of the employer and everything's case by case, of course. But I get a lot of people that weren't going to pursue a claim, and now that the employer tried to stop their unemployment benefits, they're all of a sudden like, okay, now I'm going to go contact an attorney, and now I'm going to look into this. So that happens a lot. If an employee has enough, like let's say you terminate an employee and they go look for another job elsewhere, and that job calls to check a reference, don't give them a bad reference, because I think a lot of times when people feel they're being blackballed, that may lead them to say, okay, now I'm going to go get a claim. I was going to walk away and just go find other work. But if they're stopping me now, I'm going to go see if I have a case, that's stemming from my termination. So those are, I think, some things you can do just from a human element. We talked a little bit about how you document things, how you protect yourself legally, but you want to try to beat the claim in general. Like, you want to try to prevent the claim from even coming. You can worry about beating that later, but I think just the way you treat people on the way out goes a long way as to whether claims come or not.
Well, and I think that, in the past, I think that people have said, if somebody leaves on not the best terms, that when a new employer is confirming, prior work experience, that you confirm it, but maybe not offer any additional flavor to the conversation. Is that still a good recommendation?
Right. You want to say we have a neutral reference policy. We don't say anything good or bad. Dates of employment and position title is all we'll say. Yeah, we'll confirm they worked here, and here is their title, and that's it. That's all we say, no matter what. No matter if the person was great or the worst, we keep it neutral. That would be the best thing that I'd recommend saying.
Yeah, I think that's a really good piece of advice. Now, in looking for the future, um, you know, I think in the finance world and even in the business world, there's a lot of unknowns in the upcoming future. Whether prices are going to go higher, inflation. I think there's a lot of fear going into what's happening from the economy and such. So, that could mean that there could be more employment related issues happening with people not having enough money. If we get into recession times or anything, what changes do you see though in employment law in the next coming years that we should be mindful of, as maybe there's more volatility, at least in the economy or in the political climate? Do you see anything coming down the pipeline that we should be aware of?
Right. We touched on, or you mentioned DEI a bit. So in the past, typically companies were encouraged by the EEOC, and the EEOC is the government agency that provides guidance to employers and also enforces employment laws. And while I don't foresee like the substance of any laws changing that are out there, just the way the EEOC offers its guidance and enforces things could change a bit. And right now, what it seems like the objective of the newly appointed director of the EEOC, their objective is going to be to target these DEI programs that employers have out there, meaning programs that are pro diversity and inclusion. And they're basically saying, if you are outright discriminating against the group of people to try to push diversity, that is illegal. And we're going to take those cases, try to litigate them in the court system, and get the court to make favorable rulings for what our administration is pushing. So there's probably a case that'll work its way up to the Supreme Court eventually at some point. It may happen sooner rather than later. There may be a new administration by the time it works its way up there. But what I would say is, just because that's what the administration and the new director of the EEOC is trying to push, that doesn't mean every court's going to rule that same way. So if I was a company, I wouldn't just totally abandon, trying to be diverse and, trying to, just give equal opportunities to all races, genders, et cetera, across the board, right? So you don't want to abandon that, but at the same time, you want to avoid doing things such as, well, we need to hire a minority for this position. We need to hire a woman for this position. That's what the new administration is trying to target. And while there hasn't been no laws have changed, just the way they're enforcing them, the way the EEOC is instructing its investigators to enforce things, that has changed. And I think what the new regime of the EEOC is going to try to do, they're trying to push cases into the courtroom and try to get the court to make a favorable ruling. And then that kind of becomes the law of the land if it makes its way up to the Supreme Court, or just the law of that specific circuit that they brought the case. But that doesn't mean all circuits are going to rule like that. And until the Supreme Court makes a ruling, I would be very cautious as an employer. I would still be, just give equal opportunities to all employees. And if you do things based off merit, that's fine. But don't think the way that the new regime of the EEOC is enforcing things gives you a free pass to just do whatever you want. I would still not discriminate, and I think that's what, the new administration wants to push there. I don't think they're saying that you should be discriminating against anybody. They're just saying you can't totally say, we're not considering a male for this position. We're not considering a Caucasian for this position, right? So that's what they're trying to avoid. But yeah, definitely still want to be cautious out there. But yeah, sorry, I rambled on.
That's helpful to understand, because I think that as these large companies get rid of their DEI programs, the population is not understanding why that is. Well, if they're seeing that they could get some sort of employment claim, like have these sort of reverse discrimination in some people's minds, claims coming to them, that's why they're dropping some of these programs. The unfortunate part is that I don't know if these companies really thought that through from a profitability standpoint, because, the public is going to move their money to places that, are more conducive to a, more diverse type of situation. But I think it's really good input. Now, if somebody were reaching out to you or we're struggling, typically it's not going to be the company that's reaching out to you. It's going to be the employee. And what would, if we were looking at hiring your firm or reaching out to you, what typically are you talking to employees about, or what could you give them as some knowledge of how to go about their case, or go about even reaching out to somebody like you? What services do you provide? Do you offer an initial, do they go straight to the EEOC, or do they go straight to you? How does that really work? We don't know as much about this as we should, probably.
Sure. So we would take someone through the EEOC process, and if they retained us. Now, there are some people that may have got a little bit ahead of it and filed on their own, so we could step in after the fact, assuming the case is still pending. But we typically would like to take someone through that process. But what we do, we offer a free case evaluation. So if someone believes they were wronged, wrongfully terminated, or having some issues with discrimination, retaliation as a current employee. So we handle both former and current employees. We'd offer a free case evaluation. They can call our firm. We have a phone number, 888-415-7067. I see that on the screen right now. Our website also has an online case evaluation form. You'd be surprised. I actually thought the majority of our leads would come off of phone calls, but it seems like almost 50-50 between phone calls and online forms. So we give both avenues the same amount of attention. We'll review the situation and get back to you usually within 2 business days and let you know if we can help or not. And then if we can help, then we would reach out to you. You have to sign a retainer agreement, and we get to work on your case from there. But yes, we would let you know as soon as possible if we believe that we can help. And it's tough because a lot of people are wronged, but they don't technically have a case. Right. But I would encourage anybody that thinks they're wrong, there's a good chance you have a case. So you might as well, get it looked at by someone like our firm.
Well, and it makes sense if you have something online, because I think where people struggle for legal help is they don't know if they have a case. I don't know if I should reach out. So they do a ton more research online. So if they can fill out something and get an idea, I think that's great. So we posted your website and your phone number. And if people have additional questions, they'll certainly reach out to you. I really appreciate, we know we kind of put you in the position to give some business owners some advice as well. So I appreciate the proactive information for our owners. And they also could reach out to you to kind of have proactive ways of avoiding some of this and maybe have some consulting as well. Is that something that you do or typically not?
Typically, so yeah, one of the biggest things I always pride myself in is I've never represented an employer, only employees. That's something we like to keep consistent because sometimes it poses conflicts. If you've worked for an employer, and we want to always stay conflict free, always be on the employee side. But I would say on our website, there's good information. There's some articles that may be helpful to both employees and employers alike that talk about the various type of claims that we see and give some analysis of the law on that. So that the website could be a helpful tool. Anybody can visit it. As far as advising employers, not something that I do. But I would be happy if someone, I'm happy to connect with anyone and help point them in the right direction, as far as who they should contact and how to go about finding counsel. I'm always happy to give them some kind of recommendation.
Awesome. Well, thank you, Gary. We appreciate all the information and we'll look forward to talking to you again.
All right. Thanks again, Melissa. Really appreciate it. Thanks for your time.